Hey everybody, it's Dan Kraus. I am getting ready to start this presentation and I'm just going to do the little test. So if anybody's on there can hear me, just let me know by chatting, putting something in the chat saying you can hear me and see me. Good morning, Kathy. Um, Great. And we've had issues with the volume before. So if I'm soft or too loud right now, can you let me know if I need to turn up the volume? I think I have the ability to do that a little bit. Um, okay, sounds perfect. Okay, good. I am going to just pop off for a second. I'm get myself a glass of water because I might need a drink during this, and then I will be right back. So give me 30 seconds and then we'll get going. Okay, sorry about that. All right, let's get started. All right, so today we're going to be talking about estate planning. What is it and why is it essential? Um, and so just to let you know some housekeeping stuff, we should have two pictures that you can see, the not so interesting one of my face, and then there should be a way for you to look at the slides. So if you can't see the slides, you can probably scroll up or down or to one side or another, and I will be flipping through the slides. That should work. There should also be a place wherever you are that you can chat. So there might be a button or a thing to the side where you can see the chats there. And Laura is also helping me with this. Laura Hamden. She will be putting out some polls, some questions, um, giving you some information that you can download during the presentation. So keep a lookout for that. And we would appreciate any feedback that you give us. They're just like easy questions, multiple choice questions, kind of a thing, asking about, who has estate planning and things like that. And what information that you do already have and know. It helps us to plan for future sessions and what we can focus on. All right, so my name's Dan Kraus. I'm an attorney. I practice law in Wisconsin. I'm also licensed in Illinois and Minnesota, but I don't practice much in either of those states currently. Um, I have a law firm. It's called Kraus Estate Planning and Elder Law Center. I've been doing this for about 25 years, and I have a lot of experience with this stuff. We don't do divorces. We don't do mesothelioma litigation. We don't do anything except for estate planning and estate administration. And part of our estate planning is called elder law. It's for people who are planning for trying to save assets from nursing expenses. So that's our focus. If you need a criminal attorney, I really feel bad for you, but don't call us. We're not the people to do that. We focus, what do they say, a foot wide and a mile deep. So this is what we do. Okay. So this is a little bit about me. I'm very proud of my status as a U.S. Army veteran. I've served in the regular Army, in the Army Reserves, and the Army National Guard. I'm actually, if you know anything about military or retired military, I'm a gray area retiree, which doesn't mean that my beard is gray or my hair is gray. It means that I'm retired, but I don't get any benefits until I turn 60. So that's a gray area retiree, because I didn't put all my 20 years in the 21 actually in the regular Army. I put most of my time in the Army Reserves and National Guard. So benefits don't start immediately when I retire. They only wait till I'm 60 to start. Also, I served some time in the Peace Corps. That bottom picture of me down there in the Army uniform with the BCGs on is just one that I took shortly before my retirement. A little selfie there. If anybody knows what BCGs are, those are the glasses that the Army gives you for free whenever you get your eyes checked out, but they call them BCGs, and that stands for birth control glasses. Now, they don't have any chemicals in them that do anything to make you impotent or anything like that, but they do make it so that no one will want to go on a date with you if you wear them. So that's why we call them BCGs. All right. So our firm, like I said, we concentrate on estate planning, elder law. We belong to many organizations that focus in these areas, and we also have many accolades and ratings. So we're very proud of our ability to do this type of law and our recognitions that we have received. I have written a book. It's called Estate Planning in Wisconsin, published in 2017. The new edition will come out in 2025. It's going to have some more chapters, just beefed up a little bit, but it's the additional chapters are going to be more focused on Medicaid planning, nursing home planning, that kind of stuff. And so keep a lookout for that. If you want to get the book, it's available on Amazon. I think it's $14.95. You may have to pay for shipping. I'm not sure. It's about 90 pages. It's simplified. It's not written for attorneys. It's written for real people with real issues, and it helps people just to understand the basics of estate planning. It goes deeper than what we are going to go today because we don't have time for all of that. Okay, let's see. All right, so what is estate planning? Essentially, it's arranging your affairs in a legal way, normally through signing of legal documents that can plan for if you become incapacitated, if you die, or to protect your assets during your life or even afterwards. These are things that estate planning can do. The minimum required for a comprehensive estate plan is a will, a financial power of attorney, and a healthcare power of attorney. With those three documents, you've got the minimum that's required to take care of you, to know who's going to be in charge of your stuff, who's going to be in charge of your healthcare, etc. If you don't have all three of these, you are lacking, and you really should get going on that. But many people who do have all three of these don't really have it tied all together like they should. All right, so let's talk about powers of attorney for finance and healthcare. They are incapacity planners. So for somebody who is not able to make decisions for themselves, if they have made a power of attorney in the past for healthcare or finances or both, now they have somebody who can make decisions for them. If they become incapacitated without having these documents, then there's trouble. So if they don't have the documents, what happens? Well, state law controls. So depending on what state you're in, and I'm in Wisconsin and I mostly practice in Wisconsin, so I'm familiar with what happens in Wisconsin. And this is similar in most states, but I can't say that it's going to be exactly the same. A guardian must be appointed. If you have assets that nobody can control because you're unable and you haven't given a power of attorney for someone to control them, then someone needs to be appointed the guardianship of your estate. So that just means your stuff. So the guardianship of your estate means your bank account, your house, your car, your knickknacks, your clothing, everything that has to do with things that you own or control. if you don't have that planning and you do need a guardianship, then you have to go into court, and the court takes all of your abilities to make decisions and contracts, etc., away from you and gives those to another person. That would be your guardian. So you become the ward, they become your guardian. You can avoid that by having a proper powers of attorney. So how do you know who's going to be your guardian? Well, you don't. That's a really bad thing. So if you really are concerned that you might become incapacitated, and everybody should be concerned about that, then you should have a plan so that you don't have to go with the state's plan where you have expensive guardianship, and then you lose all of your rights and ability to decide who's going to make your decisions for you. So you got the financial power of attorney, you got the healthcare power of attorney, and along with that, you have a living will. So a living will, along with the healthcare power of attorney, allows you to plan for death or leading up to death. So the case that many people are familiar with, and it was about 25 years ago now, but the most famous case is the Terri Schiavo case. Terri Schiavo was a woman who lived in Florida, and she was in her 20s. And for some reason, which I don't know, she had a heart attack, and her heart stopped beating and pumping blood. And eventually they revived her, but not in time to save her brain. So the rest of her body was very healthy, and so her organs were working fine, but she just never regained consciousness after that. And in fact, she lived for 15 years without ever being conscious, and there were court cases and news articles and all kinds of stuff because she did not have a living will. She did not have something saying that if she was in this state that she wanted them to pull the plug. So these pull the plug documents are very important in certain cases. So how do you plan for death then? So if you don't plan for your death, once again, the state law controls. In general, your closest relatives are going to get your stuff. You're going to have, or your relatives will have, probate proceedings in court. You may have problems, or your family may have problems with young people getting a ton of money on their 18th birthday. And well, we've all known 18-year-olds, and I think we've all probably been 18-year-olds. And my opinion is it's not really great for a person like that to have a whole ton of money. The money won't last, and maybe even the young person won't last the struggle to spend all that money. Also, in a second marriage situation, now there's a lot of situations where the failure to plan causes just tragedies in families, but in a second marriage situation, it's especially bad because if you have children that are not your spouse's children, things between your children and your spouse are going to get really ugly really fast. All right. So when we say somebody hasn't planned for death, we usually say they are intestate, meaning they don't have a testament or a last will and testament. So that's what we call intestacy, the state of not having a last will and testament. And here's just an example. A famous example was long ago in 1955, James Dean died. He had only made, or there was only one movie that came out before his death that he was in. Two more movies were released after his death that won Academy Awards, etc. And because of his death, they were highly publicized. He became very popular mostly after his death. And his image and likeness and name and the movie royalties, etc., garnered a lot of money, mostly after his death. Well, what happened to that? Because he died young, it's not surprising that he didn't have a will. If he'd have had a will, things probably would have gone a lot different. Because James Dean's backstory is kind of sad. His mother died when he was a child, and his father essentially abandoned him to his mother's sister. So his aunt raised him as her own, and he really did not have a good relationship with his father at all. But because he died intestate, his father got everything. And until his father died in 1995, he was receiving millions of dollars every year for the rights and the fees and licensing. Probably not the result that either James Dean or his aunt would have wanted. So, wills. In order not to be intestate, you need a will or something like a trust. And we'll talk about trusts later. Wills are the traditional way to plan for death. So if you've got a will, it says who's going to get your stuff. And it also says who's going to be in charge of making sure your stuff gets distributed properly to the people that are supposed to get it. And you can also, within the will, create trusts so that an 18-year-old does not get that money immediately. They have to wait until either they graduate college or they turn a certain age, but you can write that in your will. It's called a testamentary trust. Now there's that testament, like intestate, testament, testamentary trust. It just means that it's written in a will. So the testamentary trust is a trust that comes into effect after your death, and it goes through the will. There are pitfalls of having a will, some things that can be avoided. When you have a will and your will gets probated, that's the only way a will can come into effect and really do the work that it's meant to be done, and has to go to court, certain kind of court called a probate court. So with a will, you can't transfer assets unless there's a court involvement. A will by itself is no good. You can't just take a person's will into the bank and say, hey, banker, I'm supposed to get the bank accounts. Can you just give it to me because the will says? The banker will say, I'm sorry, we can't do that. You need to go to the court. And then the court approves the will and gives you the power to take the bank accounts. So it's only after the court gets involved that the will does any work. Very important to note, because many people think that if they have the will, they're going to avoid probate. That's not true. Now, because it's in court, there's no privacy. Most court cases, unless they involve like custody of a minor or somebody's incapacity, these are private things that they keep the hearings closed. But criminal cases, probate cases, divorce cases, these are all public. Anybody can go in and see them. And in fact, anybody can go in the courthouse and say, I want to see the file to that case and look at all the records that have to do with the court. Volumes of records. None of it's private. It's all public. So wills go through the court, means the will is public, but not only the will, but, and that's interesting. I mean, you can look and see many celebrities and millionaires, etc., that have only had a will. And so you can see exactly who's getting their stuff. It's really interesting, but not what most people would want. You don't want your stuff being aired in public. And it also invites predators, not only because of the publicity, meaning that your stuff is public and anybody can look at it, which is worse and worse in this day and age because of data mining. You've got bots crawling the internet looking for money. And where do they look? They look to more and more to older Americans, because older Americans have these large bank accounts, hopefully for their retirement. They've got retirement accounts, they've got savings, etc. They're not just trying to build something in their younger years where they mostly have debt and not much else. So all these people in India and Russia and China are targeting these people, but they're also targeting the transfer of assets, transfer of wealth after a person dies, because that's where a lot of assets are. So they can crawl the internet, they can look at these public records, they can find out who's getting the stuff, and then they can target them for schemes to try to get that money. That's one way it invites predators. Another way that it invites predators is if you have a family member that you don't want to get anything, oftentimes the probate court requires you to search them out and give them a notice that this probate proceeding is happening, and they have an opportunity then to go in and try to get something. So the probate court actually requires them to notify the person that this proceeding is going on, that there's money changing hands, and then that person can do what they can to try to grab some of it. So family members that you would like to have excluded are not always excluded. In fact, they're oftentimes invited in. So these are some problems that we have with wills. So wills are better than nothing, but not as good as a trust. All right, so revocable and irrevocable trust. Now there's lots and lots and lots of kinds of trusts. They usually name them with 3 or 4 letter abbreviations. We have the GRATs, G-R-A-Ts, the GRUTs, G-R-U-Ts, the NIMCRUTs, which is a CRUT. Some of these are charitable remainder unit trust. That's a CRUT. A CRAT is a charitable remainder annuity trust. There's all kinds of different types of trust. But the most common type of trust is the revocable trust. That's the will substitute. And the magic of the will substitute revocable trust or the living trust is that it gets you out of the probate court. It does not require you to go through probate or your family to go through probate. You don't have to deal with the publicity, the public documents. You don't have to deal with notifying people that you don't want to be notified. And you don't have to deal with the court timelines and delays, etc. Then we have irrevocable trust. Irrevocable trusts are used usually in asset protection or tax planning, charitable tax planning or other tax planning that people can use irrevocable trusts with. The most common type of irrevocable trust that we use in our office is the MAPT, the Medicaid Asset Protection Trust. This is a trust that you can put assets into, and then once 5 years has passed, they don't ever have to be used or spent on your long-term care, so nursing care, etc. So it's something that you have to plan ahead for sometimes, and because of that 5-year look-back period. But once that's all done, it's like gold. You've got your stuff in a vault and your family controls it. You don't have to spend it on your long-term care. So there's also special needs trust to protect a special needs person who may be on, let's say, Medicaid. If that person needs SSI, supplemental security income, because they can't earn a living, they're disabled, etc. If you give them an inheritance, it's going to knock off those benefits. They won't be able to get those benefits anymore until they've spent everything that you've given them. Then they got to try to get back on that program again with another application, and sometimes it can just be so much hassle there. So special needs trusts are very important. There's many uses for special needs trust. You can also have a beneficiary protection trust, what we call BPTs, which is a trust that instead of just when you die giving your children their whatever's coming to them, real estate, bank accounts, etc., what you do is you put those things into a trust, a beneficiary protection trust, and then give them the trust. Now, if they get divorced from their spouse, it won't be separated. They can't divide that trust. If they get sued because they run somebody over, God forbid, then they can't lose that. So there's protection that can be given to your heirs with a type of irrevocable trust. Also, sometimes people use LLCs, but also perpetual trust to save the family farm, let's say, or vacation property up north on the lake that generations and generations will enjoy in the future. This is a little chart that, because I always get questions, well, can't I just put POD or TOD beneficiaries on everything and that's going to avoid probate? And the answer is not a great idea, really. We see cases of this going wrong all the time. do-it-yourself probate avoidance where people don't really have education in that. The best method, the one that's solid, the one that doesn't have any pitfalls, is the trust, where you avoid probate, but you also have a lot of other definite benefits there. We're going to talk about estate tax, because many people use trusts or other things like LLCs and wills, etc., to help them avoid estate tax. They call it the death tax. Many people call it the death tax, or estate tax and inheritance tax. Both, they're different kinds of tax, but they both happen at death. And people complain about that all the time. But really, you don't need to worry about that. In fact, I would say if there are, let's see, how many people in the audience? We've got about 36 people here. I would be surprised if there's one of you that's going to ever have to pay an estate tax. Right now, you have to die with over $13 million in order to pay 1 penny of estate tax. So that's a very small portion of 1% of the population. So if you are that person that needs that, you definitely need to do some planning, and we can help you with that. But most people, they worry about the government taking a tax on their estate and taking it away from their kids. Most people don't need to worry about that. So in 2023, 13.61 million. I believe in 2024, they released the number. I believe it's 13.99 million or something like that. Essentially 14 million. Might even be just a hair over 14. But in 2026, the current estate tax law sunsets, and we go back to the baseline estate tax law, which is going to be about $7 million. Still, most people aren't going to have to be worried about that. So just keep in mind, if you are, say, at or above the $5 million mark, it's time for you to start thinking about estate tax planning. If not, and if you don't believe that you ever will be, then, excuse me, scratch that off a list of things to be concerned about. What I find more and more people should be worried about instead of estate taxes is, what if you end up in a nursing home? What if you end up in a nursing home, or your spouse ends up in a nursing home? You may lose everything, and your kids won't get any inheritance at all, even though you've saved and scrimped your whole life and you've paid off the house, etc. It can all be gone. So let's talk about asset protection for nursing home costs. So there's two types of planning for nursing expenses. They both have to do with qualifying you for Medicaid, because Medicaid is a program, a Social Security safety net program like Medicare and Social Security, that will pay for nursing costs or assisted living costs. It will even pay for home-based care, not 100% of home-based care, a few hours with a nurse and maybe somebody help you clean up once or twice a week. But they will pay for a lot of different services that people don't realize, but they also don't realize what it takes to qualify for Medicaid. So we'll talk a little bit about that. So we do pre-planning, which is when a person is fairly healthy and they want to set aside assets to wait 5 years for that window to close on the government's ability to make you spend that money. So if you put aside money, you plan 5 years in advance. If you don't have to apply for Medicaid within those 5 years, you're golden. Your assets are good. And then there's crisis planning for people who may not have done any pre-planning, and now it looks like they need nursing care, or their spouse needs nursing care, or their parents need nursing care. Now they need to come up with a crisis plan to save as much as they can at this point. We don't have 5 years to do that kind of planning. So I want to bring up disease discrimination. The government is involved in a discriminatory practice, and I want to talk to you a little bit about it because it answers the question, why do you do this type of planning? Isn't it cheating? Isn't it cheating to get access to this Medicaid benefit that you're not supposed to have unless you basically have nothing left? You're supposed to spend everything on your nursing care. before you access Medicaid. And I say to people, I don't have a problem helping people plan for this because they need it. Their families need it. They've saved their whole lives. They deserve to have these assets for their security and then pass something small on to their kids. And the reason that it's fair is because of disease discrimination. So let's take the example of two different diseases, cancer versus Alzheimer's disease. Now, if you have cancer during your old age, you may have millions of dollars worth of treatments in the hospital and at home and therapy and chemotherapy and surgeries, etc. And you know who pays for that? Medicare. Medicare pays for that, and you don't have to go broke. But if you have Alzheimer's and your treatment just happens to be in a nursing facility because it doesn't involve a lot of surgeries and chemotherapy and that kind of stuff, they say, well, you have to pay for that out of your pocket until you go broke. Well, that is ridiculous. They draw that line between care that's medical care and care that is long-term care so that they can save money. Whereas the person doesn't get to choose whether they have cancer or Alzheimer's disease. It's a deadly disease either way. Why does one have to go broke and the other doesn't have to go broke? So we help people with Alzheimer's, Parkinson's, any kind of dementia, and just the infirmities of old age that need help and they can't afford it. Get the government help that should be provided through Medicare, but is not. So if you have a long-term care situation, you need nursing care, you need long-term care, you need assisted living, what's the government's plan? Well, if you don't have a plan, the government's got a plan for you. And it involves spend down. So the spend down is where you get sick and you start spending your own money on your care, and you just keep spending and spending and spending and spending and spending until you have very little left. Now, the things that you're allowed to keep are $2,000 of countable assets. So that's bank accounts, investments, anything. Now, they don't count your household goods and furnishings, so you don't count your pots and pans, but anything in the bank, anything in investments, any life insurance with cash value, all of that counts. You get to keep your home. Oh, that's great. You get to keep your home. Wow, that's most of my assets, what some people will say. That's most of my assets. As long as I get to keep my home and that passes to my kids, then that's great. You also get to keep one car, even if you're a couple, only one car. And then a policy of irrevocable burial insurance, so you can prepay a funeral, essentially. So that's for some people, that doesn't sound too bad. You keep your home. But then the second part of the government's plan is called recovery. That's after the person that has Medicaid and Medicaid pays for their nursing care. After they die, the state comes after the home. They put a lien on the property and they foreclose on the lien so that they can recover the money that the state has paid out, because they kept a tab and they said, this month we paid $7,000, this month we paid $7,500, this month we paid $8,000, and they keep that for your whole life. And then when you die, they present the bill and they take it out of your house. So that is a state recovery. So the fact that they let you keep your house is just it's a little smoke and mirrors to make you feel good. They are planning to get their money back. So that's the government's plan, is that you pay for all of your care, whether you pay for it during your life or after you're gone, and then your family has to essentially do with less. Your plan is not the government's plan. Your plan should be different than that. Your plan should be keeping your house and your savings and everything for yourself, for your security, and then pass it on to your heirs, your kids, your grandkids, nieces, nephews, cousins, brothers, sisters, when you pass away. So there is the end of our presentation today. A little bit about estate planning. These are some of the things that people should be concerned with. Everybody should have an estate plan. Everybody should do some sort of planning, because really it's not you that suffers the most. Generally, it's the people that you leave behind. So I want to encourage you to take the next step. If you are convinced that you should have an estate plan, or if you have one that you're not sure is going to do the job that you want it to do, call us, set up an appointment, meet with one of our attorneys, and we'll talk. We'll figure out, do you have a decent plan? Is there something more that you want to do? We'll give you a quote, and then you can either walk away or decide this is for me. Let's see. Now I can take any questions. So I'm going to look to see whether people have indicated. I see one question now. How much is a trust? Oh, great. Up front, the one question that we get in all of these, how much is a trust? Well, that's a complicated question. It all depends on what you need. So I know it's a disappointing answer, but a trust depends on what type of a trust. It depends on what features the trust have. Is it irrevocable? Is it revocable? Etc. And that's what you can learn if you sit down for a no-cost consultation. So because you're learning about this, we want to give you a deal. You can sit down with an attorney for an hour and bring your situation. We talk about your specific situation. We will go through the pluses and minuses of what's on the table, and we will give you a direct quote that's exactly how much your estate plan would be. And maybe we recommend a trust. Usually we do, but not always. So now, I know that's an unsatisfying answer and doesn't get dollars and cents, which is what you want. So I want to tell you that if you want to get some planning done for a couple of $100, don't bother with calling us, because we can't do anything for you for a couple of $100. We're experts here. You may be able to find an attorney that also does divorces and bankruptcies to do a will for you for a couple of $100. I don't know. But if you have a plan that includes a trust, and it's a comprehensive plan, meaning that you've got a great power of attorney, you've got a great healthcare documents, you've got a trust, and you've got a pour over will all together, it's going to be at least $2,500, $2,600. That is the absolute minimum. We usually come out right around, let's say, the $5,000 to $6,000 mark. But if you have also planning for Medicaid, trying to save assets, so you're adding in an irrevocable trust, it's going to be more than that. But we find that all of our clients, after they're done with their choice of estate planning, are very happy with that, and the protection that you get for this amount of money, especially if you have a nice property or a farm, or a house that's paid off and you want to save that for your kids, the fact that that that's going to be secure is worth every penny. All right. If you have beneficiaries on your accounts, is that payable without probate? This is a question that I talked about earlier, so I'm not going to address that. It's a bad idea to put pay on death on all of your accounts. Do I need to have a specific amount in assets to work with you? No, absolutely not. I mean, some people have what I would consider very middling assets, not poor. Not so. If you have nothing but debt, be sometimes not really worthwhile to spend the money to do elaborate planning. But some people have very little, but they want to make sure that they exclude somebody, and you can't exclude anybody from your estate unless you have it written down and properly witnessed and notarized. You have to have a good plan. So especially if you have a child that you want to give less than another child, there's no way to do that without having it written down. Otherwise, the state's plan is going to come in. So there's no specific amount of assets, but we'd be happy to talk with you, and you can decide whether it makes sense for you or not. Because some people have a high tolerance for risk. Some people are ready to jump out of airplanes and go spelunking underwater. That's not me. I tend to have more insurance and less jumping out of airplanes. So Some people are willing to spend more money to have more security. Other people are willing to let it all hang out there and take the chance that they're going to lose it all in a nursing home situation. Okay, what if you want to make changes down the road? That's a great question. In most of our documents, as long as you're competent, as long as you still have your mental capacity, you can make changes. However, in the irrevocable trust, it's harder to change. So if you want to put assets aside so that you don't have to spend them on your care, you can't change that on your own. You have to work with people, your trusted beneficiaries, your children, and if you're married with your spouse, and you all have to agree, and then you can change things. There's easier ways to change some things, but it depends on what you want to change. So most people don't do planning with irrevocable Medicaid trust until they're in their later 60s or 70s or beyond. And the reason is because normally they're going to have to give up the immediate control of their assets to the kids. So they're already in the mindset of, we're planning for the next generation. We have to give away the asset control so that the family can keep the assets instead of watching them just dribble away at the end of life. So most of your documents can be changed. If you do documents with us and do an estate plan with us, depending on whether you're a part of our client care program or not, it's going to cost different amounts. People on our client care program often get changes, no problem. We'll do changes every year, every 2 years if you want to. But if you're not on the client care program, you can come back in. We can make changes to your documents. We will quote you a flat fee at that time, and then you can pay whatever the flat fee is at that time. Our prices change year to year, just like everything else. Can you say in your will if one of the beneficiaries contest it, they are automatically out of the will? Yes, that's a very popular provision. We talk about that with you in your design meeting. But yes, that is it's a great question. You can say if a person contests your will, then they get nothing. And some people give their least favorite person something like $1,000, because then it's essentially, here's, you get this $1,000. Unless you want to fight about it, then you don't even get that. You get nothing. So if you want to leave somebody out, sometimes it's even better to give them a little bit so that they have, because if you give them nothing, then they can fight all they want. They don't lose anything. And they can just make things miserable for everybody else. But yes, that's a great provision. We call it a no contest clause. It's also called an in terrorem clause, just for your information. In terrorem is from Latin, and it means to strike terror. So you put that clause in there and says, if you raise a ruckus and you try to contest this will, you get nothing. It makes people scared and think twice or three times before they actually start contesting the will. All right, what's the client care program? That's a great question. The client care program is run by our client concierge, and it gives you near immediate access to your attorney. We're very busy around here, and it sometimes takes us a while to get back to people. We always get back to people, but you get, I guess, the white glove service. You also get either reduced or free changes. You can have meetings with you and your financial advisor, your banker, your family each year with the attorney or the paralegal to go over your documents and say, this is the plan, and get everybody on board. Those family meetings are really great, so that also prevents fighting of the children after you're gone. We also have other events like social events, etc. That's the client care program, and we love for people to be on that, but it's not required. There's a fee for that. I think it's around $1,200 a year. All right. All right. I see we're down to about 29 participants, and I don't see any further questions. So with that, hopefully you have learned a little bit. And thank you if you have responded to any of the questionnaires. We do go through those, and we talk about what we can emphasize and help people with more at further future seminars, webinars. And thanks for clicking in and joining us. Once again, please give us a call if you have any questions about any of this, especially if your questions have to do with Wisconsin. If you're in another state, we can probably help you find somebody in your state that can help you. So give us a call as well. Thanks very much. In case, I think you probably have the number. Laura sent out some things, but the number is 608-268-5751, or on the screen you can see the Milwaukee number, 414-285-1082. Either of those numbers will get you to our receptionist, and we'll get you to the right place to be. Okay. Take care, everybody. Enjoy the fall. It's beautiful weather outside, and have a great day.